Board Member Buchwalter. Board Member Cabrera. Board Member Pavlovich. Absent. Board Member Whitlitzbach.
Here.
Secretary Dow here. Vice President Marcos. Here. And President Miller. Here. We have a quorum.
Green. There we are. Thank you. I remember going through, this is a huge job, and I really appreciate the work that you guys have done on this because I know it's very, it makes you go cross-eyed going through all of this document and revising it. Because Sharon and I were involved in that years ago on the last revision. I do have a couple, and I notice just a couple of the probationary terms have been adjusted from 1 to 2 years, which is fine because a 1-year probation is kind of hard. It's kind of meaningless, just 1 year because of the processes, the time that takes. So it's fine. I noticed that take and pass the licensure examination is appearing in a few of these that as a minimum, I believe the minimum. For example, on the first, practice without a license, minimum penalty includes take and pass the licensure examination. And there are a couple of others where that takes place. Applies to applicant and applies to licensee. And I'm wondering if that's an increase over the past, because we've been sort of reluctant to, that's been more of an optional from, I think, in the past. But correct me if I'm wrong. And then the other one is optional conditions as relevant to circumstances appears, for example, on page 11, but it doesn't, the other ones don't have optional conditions as relevant to circumstances added to them. Maybe that's because there aren't any more optional ones, but I'm just curious about how that was selected.
Just one moment, please.
Yeah, I see take and pass the licensure examination on page 7, under practice without a license, under 8, practice without a license for, and then also page 10, under unprofessional conduct. And I believe those are listed as minimum conditions. Or standard conditions. And also,
So, can you draw me to one page that you're speaking of where the example is so I can,
sure. So, page 7.
okay,
Section 2570.3A, practice without a license applies to applicant. The maximum penalty is denial of application. The minimum is license issued, revoked, revocation stayed, placed on 3 years probation with the following conditions, and it lists out all the conditions. And then down there is take and pass the last licensure examination. So when I was outpatient supervisor at CPMC for a couple of years, I had a PT who didn't renew her license. So she, if you were practicing without a license for a week because you didn't renew, and she had to drive to Sacramento and get her license fixed. So would she have to take the exam if she was an OT based on this as a minimum condition? If someone didn't, they forgot to get their license renewed, they practiced for a week, they have to do restitution, they have to do all these things, do they have to pass the licensure examination if they happen to practice for a week by mistake, according to this?
Well, this one in particular says it applies to an applicant, so a renewal.
The next page has it for the renewal.
Okay.
The bottom of that page applies to licensee. Also applies to.
Board Member Bookwater speaking specifically, this does happen where people license lapse for a week, but they're therefore practicing without a license. The question are all of these applied, I think is really,
The board always has the discretion.
that's what I think.
Always
Yeah.
has the discretion.
Right, and that will come before us.
And
we'll-
so I would say that it's unlikely that you would want that term in for somebody.
So, yeah, because that's what I was wondering, because the way this is worded, the wording has changed a little bit. It seemed like that might be a standard condition for everybody, which it should be for somebody who's practicing without a license. Most people, many people, if they're practicing without a license for 5 years, for a long time, which we've had also, I would say absolutely, yeah.
So as legal, I'm looking at the overall summary for all the penalties for violations, and it states that the conditions of probation stated herein are to be considered. And
Considered,
Yeah,
okay.
so all of these were probably common or something for the board to consider for each one of these. So it's one thing to practice without a license for 4 minutes while you were renewed, and it's another to just go 4 years without renewing. And at that point, maybe we need to chat and have you retake the license, but it's fully within the board's discretion as to what terms to impose at a particular factual pattern.
And this goes to the administrative law judges, right? So when they do a decision, this flags them to make sure to look at this
Yes.
conditions. So that would be, not having that there, that might overlook that as one of the conditions, but having it here.
It also permits
to mind.
the Deputy Attorney General to argue for specific term of probation if that was appropriate, to say this is, if probation is adopted by this ALJ, we ask that these terms and conditions be included.
So it's not prescriptive to make someone take the licensure examination, but it is prescriptive to make sure they consider whether or not to
Yes.
consider to impose that.
Yes.
Okay, then I'm fine with it.
And to further on that a piece, when you looked at it, line 8, my memory, if my memory serves me correctly, because I remember, and you were on the board, and you were on the board as well, and Board Member Pavlovich was on the board, and maybe this came up earlier when you were on the board. I do remember that we really deliberated on the take and pass exam because of one case.
Yeah.
And then what I remember about this, and we could look at the minutes, but what I remember about this is specifically we went back and applied it where it made sense. So like under advanced practices, it's not there because it doesn't make sense.
Gotcha.
And I will add that it is within the board's discretion to also lower the penalty. And so if an ALJ were to include that and the board felt that that was not appropriate, the board is able to omit that particular term and condition.
We did deliberate on a case just like that as well in the past. So we did look at that and do that. All right.
My other
Yeah.
comment was about on page 11, under section 2570.28A, unprofessional conduct, disciplined by another government agency, the final bullet is optional conditions as relevant to circumstances. And that appears also on the top of page 13, under violating provision of the OT Practice Act. I'm just wondering why, it's showing up as a bullet in those two, but not any of the others. And I'm just wondering, is that all, is it always optional? Is it always possible to do optional conditions as relevant to
It always
circumstances?
is, yes.
So is it either necessary to have it here, or is it necessary to add it to all of them?
I think because this is also used by the ALJ, the reason on page 11, under discipline by another government agency, optional conditions as relevant rather than listing them was intentional. The one over here for any violation or violating any provision, I can't remember the background about why it was there, but I think that given the type of action that another state agency might take, I think it's a good idea to not list the whole laundry list and instead force you to take things out, but just to kind of highlight, go back and, go look, and maybe none of them are relevant, right? And I think that's, or wouldn't be relevant for probation monitoring.
Okay, and so the other violations, it's not worth putting it in there because it would be a waste of their time
Well, they'd spend more time
going through it.
going through, like flipping back and
Yeah.
forth, right? Because the conditions are at the end. Then they spend more time doing that than saying, okay, well, this is about fraud. Like maybe they need a work site monitor or.
Okay. So it was selected for these particular ones because it would be more likely to be the kind of thing that would require
with
tailoring.
consistency, disciplined by another state agency. You don't know
Gotcha.
what it's going to be, but these other ones, you have consistency in terms of the terms that should be applied or could be applied, but you don't have in the other one.
Thank you, that satisfies my question.
And also one other thing.
But I would, if I may, I will tell you, I'm glad you asked that question because what it sparked for me is it made me go and look and make sure probation costs was on every single one.
Oh, yeah.
The other, maybe for more for the public and the new board members, but one of the reasons that if you look at the terms and conditions of probation, they are numbered, right? Term 1, everyone has to obey all laws, right? Comply with quarterly reports, etc. The problem that the board had, though, is that when the proposed decisions were referencing them, they were not renumbering them, right? And so that was one of the ways the board said, let's minimize these errors, excuse me, by not listing them by the numbers, but just have a bulleted list, right? And so they're supposed to be numeric in the board's order, but then it might be, consecutive numbers, and then it would say 17 and then 20, instead of taking that 20 and renumbering it to an 18, because it's like a copy and paste, and they literally just pasted it. That was sort of the impetus for well, why are all these terms listed with just the bullets, and under each one of them, you can see where the minimum and maximum, you can see the condition numbers are stricken. So I just kind of wanted to.
Thank you for that. Any other comments? Any comments from our public?
Do you need a motion?
Yes. Yes, that'd be great.
I move to approve the proposed regulatory text to amend sections 4101, 4141, 4146, 4146.5, 4147, 4147.5, and section 4149.1. That was 4149.1, sorry. And to add sections 4146.1, 4146.7, 4146.8, 4147.7, 4141.6, and 4141.7 as presented, and direct staff to submit the text and other required documents to the Director of the Department of Consumer Affairs and the Business, Consumer Services, and Housing Agency for review, take all steps necessary to initiate the rulemaking process, and set the matter for a hearing.
Board, before we get a second, Board Member Bookwalter, could you just repeat 4149.6?
4149.6.
You need a second.
I'll second.
Motion by Board Member Bookwalter, a second by Councilman Marcos. We're ready to take a roll.
Board Member Bookwalter? Oh, sorry.
I did ask our public, but I'll ask you again. Okay. Great. Sorry to interrupt. Go ahead.
Board Member Bookwalter?
Yes.
Board Member Cabrera?
Yes.
Board Member Palovich, absent. Board Member Witzelsbach?
Yes.
Secretary Doe, yes. Vice President Marcos?
Yes.
And President Miller.
Yes.
Motion carries.
Okay. We also need a second motion on this same item.
I move to delegate to the executive officer the ability to make edits to the text that are consistent with the law and substantially similar to the text of the policy approved by the board at this meeting.
We have a motion. You need a
Second.
motion by Board Member Bookwalter, second by Vice President Marcos. Do we have any comments from the board? Any comments from the public? Okay, if we could take roll call, please.
Board Member Bookwalter?
Yes.
Board Member Cabrera?
Yes.
Board Member Palovich, absent. Board Member Witzelsbach?
Yes.
Secretary Doe, yes. Vice President Marcos?
Yes.
And President Miller.
Yes.
Motion carries.
The next item before us is Agenda Item 11, discussion on whether occupational therapists working in pelvic health can perform internal examinations and provide various other treatments. In your packet, you have a few different articles on this particular role for an occupational therapist. We also have a public member here who has subject matter expertise in this area. So, opening it up for discussion. What's before us is discussion on whether occupational therapists working in pelvic health can perform internal examination and provide various other treatments. That's the discussion that we're having here. And if you prefer, we can have our public member weigh in. Thank you for identifying that. Everyone noticing? Thank you for coming back to
Number
it.
4. Very front, number 4.
Can you pull out the? Hold on, just a minute. I have the public comment right here. Okay, thank you, thank you. Okay, so starting first with, earlier today, we had a public comment that was received via email. The comment is as such, I noticed item 11 on the agenda for the board meeting on August 24th, 23. I am a pelvic health occupational therapist working in Campbell and the greater San Jose area in California. I own my own private practice where I provide in-home and in-office OT services to the perinatal and chronic pelvic pain community. I have received extensive postgraduate training to gain competency in areas that include internal assessments and treatment techniques, as well as external manual therapy assessments and techniques. Given my scope as an occupational therapist supporting clients with bowel bladder dysfunction and sexual participation, these skills enhance my ability to provide the highest quality care to my clients. I always receive consent, both written and verbal, before any hands-on techniques is utilized, and provide education to my clients thoroughly. I provide trauma-informed care with every client, as I have extensive training in perinatal mental health and sensory processing in order to responsibly provide these forms of assessments and interventions. I welcome ongoing communication with the board and am happy to provide any additional information about my expertise in this practice area. I also see you. There's a second item, but it's separate from this. But the concluding comment is I also see you will be discussing AB 47 on the agenda and would like occupational therapy to be included on that bill, and I think it is important to bring to your attention that bill is related to pelvic health. We will be addressing that tomorrow. So in addressing the public comment, or in receipt of this public comment here, if we could just remember that's what's before us is discussion. Tomorrow we'll be addressing the legislation. And thank you to our public for this comment. Okay, that's so noted. And okay. Any discussion? How about from our public?
Hi, everybody. Thank you for having me here, or the opportunity to be here. So speaking on behalf of our professional association in my role as advocacy chair, but also as a private practice owner specializing in pelvic health, I just want to really bring to all your attention the important work that is happening in this space. I actually just went to a conference over the weekend where 100 occupational therapists and occupational therapy assistants from around the country got together to speak about the work that's happening related to pelvic health. People across the country are providing internal assessments and treatments, manual skills, biofeedback in order to support clients to returning to any occupations that they need and want to perform. We had an inspiring presentation by the AOTA president, Allison Stover, who has identified women's health and pelvic health as one of the top 5 priorities of the National Association. And really highlighting the fact that anyone with pelvic floor dysfunction, it influences all activities of daily living across the board throughout the lifespan. And so it's an area that I am personally and professionally incredibly passionate about. I feel that occupational therapists are exceptionally well suited. I want to say that we're some of the top providers in this work, not because given the muscles and the bones that are obviously influenced in pelvic floor dysfunction, but our role and our training and background in mental health, trauma-informed care, just really approaching people in a holistic way, we provide a really important skill set around this work. So just wanted to bring it to the board's attention. Certainly this is an area where there's ample continuing education opportunities for OTs, and the continuing education providers recognize occupational therapists as being able to take those continuing education courses that might be taught by physical therapists or other providers. Often midwives are part of those courses, et cetera, as well, but occupational therapists are recognized in this work. And so it is an area that we can get this additional competence and training to be able to provide care safely to our informed consumers. So I'm happy to answer any additional specific questions that you all might have, but just want to make sure it's on the board's radar. given that this is something that we're going to be seeing increasing involvement in with occupational therapists throughout the state, throughout the country, and connected legislation, which I know will be discussed later on. So there you have it.
Do you mind staying up
Sure.
here in case more questions come up? So does the board, specifically the practice committee, do you think based on the trends, this is worth it for you to look deeper into this, to call in a committee member to come back with a recommendation to the board? Should it, as we can see with the regulatory language we looked at earlier, swallowing it, is this something where you can imagine one day the board would put language about it, and should we start that foundational work now?
I mean, I guess my thought would be, do we have to go through all that, or can we just make a determination that it is part of our scope of practice? I mean, AOTA has identified that it is, definitely. Why are,
That's not my question. I want to know if you want to put language about it. I'm already aligned. I already thought where you were just going right now, that we all agree that it's a part of our practice. I want to know if the board, and I got that from previous meetings, is that everybody else's? So I just want to know if the board wants some language put around it, and does it make sense to see if the practice committee wants to do this?
I don't remember the practice committee coming up with language in the past.
And maybe I'm using the word wrong. I'm looking for a recommendation. Well, let me ask it differently. Following, so if we all agree, just in terms of, if we all agree, which we'll get, that this is within the scope of occupational therapy, then what's the next action step following that? So we all agree and we're aligned.
Um,
Oh, I'm sorry, I'm not using my mic. Sorry, I'm using my mic.
Well, I guess that depends on, the board has to decide if they think that it, similar to advanced practice, that there has to be additional, training and to ensure competency and minimize consumer risk, or alternatively, that no language is necessary and you're just going to rely on the ethics of the practitioners to make sure they have the knowledge, skill, and ability to provide those services.
Okay, well,
So
I'll tell you my thoughts on that.
you've got
I mean, I don't think this practice area is any different than any other practice area. It's certainly, I'm trying to get away from using the term advanced practice because to us that means something legal. And certainly it requires a specific skill set, but so do a lot of things that we do. And I don't know why we would treat it any differently. I mean, I think we kind of want to get away from that. I mean, clearly we shouldn't be doing things that we're not trained to do. That it says so in our statute. So I don't know why we would treat this practice area any different. Personally, we don't do it for things like perhaps, I'll give you an example, lymphedema or pediatrics. Huge practice areas for a lot of practitioners that require specific skill sets. That's my thought on it. Other people may feel differently, but that's how I feel. I don't know. Don't we want to get away from identifying certain areas of practice that require additional training and just rely on our practitioners to do that as the law requires?
So, anybody want to answer that? I do have a comment, but please, anybody? So, I guess what I'm wondering is, I can see that perspective, and I could be so moved in that perspective. To me, when I think of when I think of the internal nature of this, and then I think of what protecting both that consumer and practitioner, I'm wondering if there's language that needs to be around this, similar, and I see it consistently along the lines of how we have, then why do we have language for swallowing, is really my.
Can you weigh in on that?
Yeah, well, the reason we have language for swallowing is because of the politics of when we became licensed. The fact is that my experience, I have two comments. One is reading this, most of the materials here did not discuss internal examinations, except there was a discussion of tone in the, having an asymmetrical tone that affected the vaginal function, I believe. And how can you find that out unless you do a physical examination? The other one is the issue of bowel and bladder function when you have a pelvic dysfunction, and then the technique where you push, you support through the vagina into the bowel and help support the defecation by providing a little bit of extra, by providing a nudge so that you can defecate. And this reminds me of my spine. I have the large spinal cord injury clientele. Everybody who has quadriplegia at Kaiser in San Francisco gets a wheelchair from me. Now, I don't do their bowel and bladder function, but every single one I document. I have to get specialized seating for people who have to be up for 30 minutes or more to defecate because they have the muscle tone's all affected, and perhaps they have to have digital stimulation, or they have appliances that stimulate the bowel function to help. Otherwise, they don't have a bowel movement, and then also laxatives and things. So this is my end of it. Is not. I'm the last person who knows anything about women's pelvic health, I have to say, but I'm familiar from the other end, and every spinal cord unit with occupational therapists and physical therapists is doing bowel programs with people who are paralyzed, have the paralysis of those muscles, and it's been going on forever, forever since the beginning of spinal cord injury care. So I do see it as integral to occupational therapy practice from the beginning. What's new is that we have more awareness that there's an underserved population, women, who have pelvic issues that have been not addressed. And then that we are in an enhanced environment where things, bad stuff has happened. So it brings to our attention the potential for abuse. I do feel like I do agree with Christine, that it is part of occupational therapy that you shouldn't be doing it. We have statements where you shouldn't be doing something you don't know what to do. The vast majority of what I'm reading in these articles has to do with behavioral interventions, mental health interventions, perhaps training interventions where a person who is able to can go in and perhaps provide, learn about his or her body and how that works and perform the interventions. Kegel exercises, I don't need to go in and
No, but it does call out
but
in
there are
each
people who
article.
can't. There are people who can't, and those are the people who need us the most. So
And it does call out in each article. I thought that it was very specific about dividing between the techniques and the internal examination, which is a part of it. But that's not as much the part that concerns me. With your explanation, I could be so moved. What concerns me is I am a pelvic health occupational therapist. Is that how the profession is identifying themselves in this field? Because I don't say I'm a bowel and bladder, I'm an ADL occupational therapist. You see where I'm going? So
Yes. There's definitely a movement within the occupational therapists that practice in this area to identify as pelvic health occupational therapists, because the broad public tends to say pelvic floor physical therapy. Oh, I'm going to see pelvic floor physical therapy. And they might be seeing an OT, but they just label it as physical therapy. So OTs are wanting to advocate for our role in this space, and looking at some of the behavioral, the elements of habits and routines. And so there are a lot of occupational therapists that identify in that way for purposes of highlighting their work in the specialty area. And also just from a marketing perspective, or like a public awareness perspective, given that this is a conversation that people don't tend to have openly, people will introduce themselves as that to open the door to say, tell me more about that. Oh, I didn't realize it wasn't normal to leak, etc. So yes, that is something that people will say.
I don't think it's any different than my friends saying, oh, I'm a pediatric occupational therapist or I'm a geriatric occupational therapist. I think it's just kind of explains more since occupational therapy has such a wide breadth of what we do. But I also want to make the comment, pelvic health, I know this because we do it, I don't do it. We do it at my medical center. It's not just women. I mean, you may be just doing women, but it is also men as well. I'm not exactly sure what is involved with that, but it's also men as well.
Yeah, prostate cancer, et cetera. It's also pediatrics. There's a colleague, a faculty member here at Samuel and Merritt whose expertise is pediatric pelvic floor therapy. You can think about children who have sensory challenges or might be still wetting themselves and how that impacts school and the family dynamics and all of that. So there are people that work with those populations and there's biofeedback and manual therapy, not internal assessments with that population so much, but
We also have the anal cancer population and the anal prolapse
yes.
population.
Yeah, so it is. It's all genders, all ages.
They do talk about splinting for that, which is an interesting, I don't know much about, but that was mentioned in one of the articles, to evacuate bowels.
I have another comment. Can I? Okay. I think, too, and this might just be my own thinking, but I could be totally off base, but I think sometimes people start to feel like, oh, well, it's you're inside someone's body in their vagina or their anus or whatever, and I think people have a certain feelings around those private areas. But I'll go back and say there's nothing special about those areas other than the fact that they're inside the body. I mean, OTs go inside people's ears and do cranial sacral therapy. We go inside their mouths and do lymphedema and swallowing. And I mean, we are inside people's bodies already. It's just a different anatomy. But I understand how you could, it's that area down there is related to sex and sexuality and things that are considered more private. So I think, I don't know. That's all I'm going to say.
I mean, in the end of the day, it's yes, you are, but are you trained to do that? So if one is trained to do that, then you should be able to, if you're qualified, trained to do that, you know exactly what you're doing. That I have no problem with that, but that's where cannot have a gray area, right? So are most occupational therapists trained specially for this, to do the internal examination? Because based on this, it was mainly you can do it via Zoom. I'm not trying to simplify it. I'm just
Yes. It's not a current ACOTE standard that's taught in every program. There are a lot of academic programs that are including this content either in elective courses or as a part of some of the existing standards about why pelvic floor function matters. Certainly internal coursework is not provided in institutions, but anyone practicing in this would have received additional training to be
where
able
would
to.
you get that?
There are a bunch of continuing education providers. A prominent one is Herman and Wallace. It's a physical therapy continuing education provider, but there are also several occupational therapists that offer continuing education courses that are approved by AOTA for continuing education in all these areas.
This is where it's a little bit gray area for me, because when it's accredited from a university, it's one thing versus just a course that you take.
Through an AOTA approved course, though.
The AOT, is that what you said?
Yeah, yes.
That coursework is approved, it's based on the standards, the education standards that is part of AOT. They're called
Right.
ACOT.
This is legal, if I may. Could we take one moment and let me confer with the president quickly?
Sure.
Thank you. Are we back on the record?
We're back on the record. So we were explaining the guidelines and such. We have a comment from, is now a good time or okay, go for it.
As legal, my concern with us being a enforcement and licensing board and protecting the public, but also addressing and providing outlines for our licensees. Um, my concern, maybe, and that's I don't have an opinion. I'm trying to figure out how to advise the board in that if someone who was a professional said that they could insert themselves inside a patient, but there was nothing in the law or any type of permanent guidance that they could do that, what would protect the licensee and also what would protect the patient in knowing that this was acceptable, as opposed to, for example, there's been discipline against uh, nurses and other techs who have used items to insert inside of women, claiming that it's part of the process when it's not, or things of that nature, where we walk into this disciplinary area of, no, I'm allowed to do that. Here's something that is set forth that says this is within my scope, or this is not within my scope, and now I don't have anything to back me up. But I promise, because on this date, the board said they all understood it was part of the process. So that would be my concern in advising the board in how to handle the public health, not only to uh, provide communication to the public, but to also assure the public that this is indeed part of the practice. However that's written, whether it's appropriate for our laws and regulations or it's appropriate for some outline of standard of care, that it may need to be something that is addressed not only for the protection of the public, but for the licensees.
Okay, yes. Yes to all of that. Okay. So it never is something where I'm going to do this to you. It's very collaborative and would be offered as an option to clients. And certainly, again, is always done with consent, verbal and written. I hear your points, and I think that would be a conversation to have. And it's certainly not something that every practitioner provides. In looking at state boards and trying to, it's like a moving target. Different states are doing different things. And so there are many states that say nothing. Oregon is an example where they do say that this is within our scope. And so they specifically outline it in their states. I have not found any other states that explicitly outline it in that way. So it's seeming like it's more neutral or not stated, and then it just would be up to the individual licensees to demonstrate their training and expertise, et cetera. So not a full answer, but just some comments.
And I did want to add, I wasn't trying to add to the conversation, but advise the board. And I can think of, for example, chiropractic care.
Yeah.
It is part of the process to have to touch the tailbone. And of course, you advise the patient, and can I do this? And this is what I need to do. But there's also some fuzzy line at which point there are complaints that are submitted where this moved from a professional technique to a not professional technique. And so my concern is that insertion becomes really hard to define as this was okay without something in writing somewhere. And so we may not be the appropriate place to put it, but that is something I wanted to raise with the board to protect all parties involved.
So, thanks so much. Do you want to pull up a chair?
Sure.
Are you tired of standing? Okay, so couple things. Remember, it's discussion and possible action. So we can just watch and keep inviting Carlin back. We can explore and find out more things that other states are doing. Today, we could say that we think it's within our scope. For all the reason legal outlined, that is, I'm not weighing in on whether I think it's in or, I thought that was just a given, but I am weighing in on what legal provided as examples is really where my concerns lie. But I'm just one board member.
I have a thought, which is, I mean, Helen, you mentioned the nurse the nurse example. Nurses insert suppositories all the time. It's a type of medical administration. Is there a wording around what makes that different from insertion that's abuse? And that's something else. And then what does that wording look like in law in other professions and states where and nurses do this kind of thing? Nurses do internal exams. Gynecologists do internal exams. Proctologists do exams.
That's what I was hoping the practice.
I've had a prostate exam, personally, which involves insertion. And so what is the wording around that allows that to happen? That
may be a bit beyond my scope, or perhaps staff could prepare something, and then I would work with staff to make sure it was legally appropriate. But the
But we,
the
as a
issue in-
board, Helen, can
Yeah.
request that staff, to all
Correct.
the points that Board Member Bookwalter called out, we as a board can request for that kind of language, or request that the practice committee look at it.
Or that some type of language that an OT can practice pelvic health, including internal pelvic health, is set forth in some form of standard of practice. For example, all the methods of practicing accountancy are not within the Practice Act, but they are referenced as part of, these are the standards to look at. And so if there was something that a licensee could point to, but I think, for example, the nurses context, it was specifically something that was not supposed to be inserted. That was inserted. And so that's where that path comes in. But as a
So why can't we do the
consumer,
same?
you wouldn't know.
Yeah, so but you wouldn't necessarily outline, you don't necessarily have a laundry list of these are the things you can put in and these are the things you can't.
Correct.
And having that is restrictive in its own way. And that, to me, speaks to Christine's approach, which is it's another practice area. If I'm paraphrasing you correctly, Christine, it's a practice area like any other that some, people get different degrees of training in, and we're responsible for not doing a thing that we're not trained to do. I wouldn't do it because I haven't been trained, but I would. Other people won't get people wheelchairs, they can't, and I get people custom wheelchairs. So, and I learned that on the job and through school and a variety of ways. But I'm not coming to the board and saying, can I get somebody a complex wheelchair, or am I responsible if they crash it? Do I need to have that and regulation because they were, too demented to actually, use it? So,
Well, and some of this may be for the board to measure out, but as legal, in particular, that is it's a much more personal area and much more subject to harm than perhaps your knees. And so if the board feels that there is adequate protection, then certainly that's the board's position. Or if it's listed somewhere as a method or an area of the body that an occupational therapist can manipulate, then that would be something. But if it's just generally known, but there's nothing to protect either the consumer to know that what I'm being asked or offered is appropriate, or as the licensee, what I performed was appropriate, then it becomes fuzzy in a very sensitive area. So again, maybe it's best in some body of work that sets forth all the tasks that an occupational therapist can do. Maybe it's something we need to list in our own laws. Maybe it needs to be an advanced procedure. All of that will be within the board's purview, but for my purposes as guiding the board, that would be my biggest concern, is if someone came before us saying that either a complaint, this occupational therapy did this to me, or they asked if they could do this, I wasn't sure if they could do that, what would the board point to say that this is appropriate? Or a licensee is accused of some type of sexual assault, what would be something the board could point to say, no, this licensee was within their scope?
Make a comment. I'm thinking about, so there's a condition called vaginismus, where basically the pelvic floor muscles are very tight and people can have painful sex. And an intervention for that is dilators, like of progressive circumference or diameter, and patients are educated on how to use them. And so that would be something like besides a finger or, something that would be penetrated or somebody would be penetrated by. And that is a standard practice of care. This is making me think of I've heard a previous story of a person who was restraining a child, but really it was proprioceptive input that they were being that the child was receiving, where any experienced occupational therapist, pediatric occupational therapist, would know, oh, that based on the case might have been appropriate. Similarly, a lot of the content in this area might fall under that category, where if you were to ask any practicing occupational therapist working in this area, they would say, yes, that is standard practice. So just kind of an example that came to mind.
Yeah, I want to follow up on that comment. I was going to say exactly kind of going down the same road as you. I think, I've been a subject matter expert on some cases where, people have gotten bruising from maybe a manual technique. And the gist of the case was, oh, this person was abusing me or whatnot. And, because my area of expertise is upper extremity exercise, it was my job to opine on whether the therapist was doing something that was, the standard of care. And I think what we would do in this case, if there were a patient who felt that they were being abused, we would get a subject matter expert in the area of pelvic health and have them opine on whether what they were doing is the standard of care. I mean, that's how we would treat that, and that's how we've always treated it. These sorts of things. Heather, have we had one or more cases of therapists providing care under the guise of pelvic health and been accused of sexual assault?
Not to my knowledge.
Okay.
I don't believe so.
Within occupational therapy.
Yeah, within occupational.
So I'd like to follow up on that. No, I was looking into that when this was on our agenda. I'd reverse it and say, will there be occupational therapists who have abused, and we've seen an uptick in that, that's an accurate statement, who have abused patients sexually, will they say that this was in scope? So it's just flipping the question. Again, we can't know, but we can't know, and I'm not bringing up an alternative, I'm not bringing up an opposite opinion because I'm against it. I really don't have an opinion. I agree, I have an opinion that it's in scope for the occupational therapist. Again, I'm one of many. But then the next statement is, does the board make that statement? I can think that as does the board make that statement? If the board makes that statement, is there an action behind it where we put language? That's where I'm trying to move the discussion. Or do we say nothing? Which is really up to.
I mean, I think saying nothing is best for now, at least because people want to, if somebody asked us, will you make a statement saying that this is okay? Because they, for whatever reason, that they needed that. But I don't think that we're in a great position to do that because it's not always, because sometimes it might be okay and sometimes it might not be. It's not going to be okay.
But 3 times I've asked, why can't we consider sending it back to the practice committee? What do you?
They'll have the same problem. And it comes back to the board ultimately to make a decision about the practice committee.
Right, but in the practice committee, you might have experts that you could bring, right?
They would probably, but then they would be directed to make a statement. And if we don't want to make a statement, then we shouldn't send it to the practice committee.
Do we not want to make a statement? Earlier, do we not see ourselves making a statement on this? Because earlier I heard it is within scope. And we agree on that as practitioners, but are we then going to say the board doesn't make a statement on that? So we all individually agree as practitioners, but as board members, or practitioners, we're not going to make that statement?
Well, Carlin has agreed to serve on the practice committee, so she will be our expert in pelvic health on the practice committee. So I'm just going to say right now that probably what will come out of practice committee is pretty much what she's talking about. I mean, we're not going to get any new information. I'm perfectly fine with it going to practice committee, but we're not really going to get any new information. Ultimately, the board has to decide.
Right. So, and then because it's a committee and because you're knowing now that Carlin's on it, you will let the board, we'll either know through, we're going to know a couple of ways. One, it's going to be an uptick in trends. Two, the practice committee is going to recommend to the board that we dialogue further on it, or there's going to be an offender. So somehow it's coming back before this board for dialogue. Yeah, I'm okay with that if you want to go, knowing that she's on the committee. Yeah. Anybody else? Beata?
So basically, you just want to send this to practice committee. Is that?
No. I'm only responding to your statement that it is going to practice committee.
I said if it were to.
Well, the discussion and possible action is still left up to the board. So so for example, do you, in the original question I asked, does this board want to come out with a statement or not? In listening to this discussion around this, do we want to, we suggest it goes back to the practice committee, but we know that she's on the practice committee, so, I mean, this whole discussion is what's up for the action. The action isn't
I would be
just
willing-
based on what I
I would be willing to suggest a statement around, pelvic health is an area of occupational therapy practice, and there have been no violations to our knowledge of pelvic health in pelvic health practice, and leave it a more general statement like that, and not address the issue of the internal examinations because we don't have much to say about it.
I would support Richard, but just leaving off the part that said there's been no violations, because also I agree with Denise, that that doesn't mean we're not going to have violations in the future. I mean, we just can't know that.
Right.
But I agree with Richard. I mean, I think we could go ahead and make a statement if the rest of the board were inclined to agree with that. Maybe they're not.
Say your statement again without the no violations. Can you say it one more time?
Just that pelvic health is I would say a long-standing area of occupational therapy practice. That includes, we don't have to include all.
Wouldn't we want to say that's within the scope
Yeah,
of occupational therapy? Yeah.
Yeah.
That would be
the
okay
word
for
scope
me.
would be right. What would you tell us?
I feel like I'm speechless. Yes, I would be so enthusiastic to see a statement saying this is within our scope of practice. We're well suited or well qualified to address pelvic health, pelvic floor dysfunction based on our practice framework, our existing practice framework. And it could end there, or it could say, and with relevant, training on interventions, associated interventions or something beyond that. But just having it out there that the board acknowledges this as an existing practice area would be significant.
Could the statement include a reminder that, as with every practice area, you shouldn't be doing things that you're not trained to do, or something along those lines?
That would be great.
I could get behind a statement that left off qualifier words like well-suited and well. I think if we say it's in scope, it's clear enough and implied based on being a licensed occupational therapist. I could get behind a word that said scope, add language that you've identified, or for the statement. I don't know that I could go, that's where I think there has to be more discussion where you go into,
Yeah, no, I think that's great. It's within our scope.
well, there was a little bit more.
Or maybe tighten the actual scope the way we did today, physical agent modalities, where you then specify you have to be trained, you have to have certain courses, qualifications to do this.
I can't get behind that. It has to go to a practice committee to do that, to make.
But we have to tighten it, right, because we want it to be more clear.
That's
what they can and
ultimately what I
cannot do.
wanted,
Yeah.
but they don't, that's ultimately, but we're not in consensus about that. What we're in consensus is about scope, and your comments are so noted, but I think she's on that. You're identifying what I opened with, that they've moved us to scope. Because to go down that,
Are we trying to look at specific interventions to do this?
The original, I'm sorry. I'm sorry. Do you want me to?
Go
answer
for
that?
it, go for it.
So originally, somebody asked us to rule on whether or not an occupational therapist could do internal examinations associated with public health. So this all came from somebody asking us, to make a statement. And every once in a while, we get somebody who wants us to say, yes, you can do something. I can do something, because maybe they're getting pushback from their facility, or from maybe they don't know. They don't want to do something they're not allowed to do. And then we have to figure out whether we want to make a statement about that or not make a statement about that. So we learn, and not all of us have experience with these areas of practice, but we come at it from different directions. So we have someone like Carlin come in and tell us the experience. We get information and put it in here so that we understand what's going on. Obviously, there's research and treatment going on. So there's always a tension between people wanting us to list everything that we can do. It's helpful to the board because then they can say, oh, this person, that's not on the list. You didn't do it. You can't do it. That's an easier way to enforce things, but it's not the way the world works. The world works is that the things evolve and treatments change and things don't get on the list because maybe it's something new. And then we end up, you don't want to create a situation that's ripe for abuse, but you also don't want to restrict and if it's an emerging area that's helpful to people, and you don't want to limit treatments that are available, access to treatments that are important and available to people.
And if it's within scope, why wouldn't we?
Yeah.
It's really, so what is the action? Are we ready to talk about what the possible action is? If we make a statement, Helen, we need a motion, right? If the board's gonna make a statement on this particular practice area, we need a motion?
The board generally does not take a position by merely just making a statement. The board tends to speak in the form of laws and regs. And so, as I mentioned earlier, it'd be difficult for a licensee to refer to specifically this meeting to say on this date. There might be some information that can be placed on the website, but you may want to direct staff as to how best to make a statement or make it clear or somehow for the board to speak. But announcing it I'd have to research, but I don't think that we can just announce it so at this meeting, if that
Could
makes sense. I don't have any authority for us to reference saying this is the basis that it's part of our scope of practice.
could we direct staff to put something under frequently asked questions on the website?
That might be an option. I wouldn't be able to officially say yes or no as legally appropriate. It certainly wouldn't hurt, but as to whether or not it's an official position of the board or if there's something else we can reference, I'm a bit out of my scope for that. But I can work with staff to see how best we can make this happen.
So on that note, if we were to table an action, do you think by tomorrow, I'm truly asking, I'm not do you think by tomorrow you could come back and tell the board what you found so that we could either take action or?
I would not feel comfortable with that. I'd want more time to look at what we needed to do, if anything. What I would be comfortable with is if the board wishes to make some form of official position, it would need to be more than merely announcing it so. But as to what form that must take or could take is a bit more than I think I would feel comfortable in researching in the form of a few hours. And also
Okay,
sleeping.
thank you for that. So then this would be an item, would the board be comfortable if this item was brought back to us in our next meeting? Okay. Down here. Yep, Okay, so, so what we're gonna do with agenda item 10, great discussion, thank you for being
Thank you
here,
all.
please come back in December. We'll get, I think, what the action is that, and you have to,
This item doesn't require an action other than directing staff to bring this forward at the next meeting. A motion never hurts or is forbidden,
Right.
but it's not necessary to merely set it for further information at the next meeting.
so, I know you like those motions on this, so I'm gonna ask someone to make a motion for staff to, review and bring back. Who wants to make the motion?
I'll do it. What do you want?
Tell her what you want, Ellen.
Okay. I move that the board directs staff to bring this agenda item back to the next meeting with further information and
Well, the president
advice.
just sets the agenda. I can just do that.
Oh, that's why I said there was no motion necessary.
Okay. No, you said if we could have, okay.
Yeah, nothing forbids
Okay.
a motion.
Do you want to pull that motion? We don't need a motion. I thought she asked for one. We don't need one.
Okay, disregard. I pull that motion.
Okay. Great.
All right.
Okay. So, okay. That's item number 10, 11. We're moving on to agenda item 12. Do you?
Oh, yes, that's me.
Yeah.
Okay.
So the next two items are just reports by the executive, their updates by the executive officer and myself. You do not have these items in your book. All right, Heather.
So for item number 12, in the month of September, there will be the ad hoc committee to meet and discuss the non-licensee criteria to be on the board committees. There is the Disaster Response and Preparedness Committee. There is the Admin Committee, which will be covered under, why they're meeting again will be covered under item 14. And then also subject to everyone's availability, if not late September, then early October, the first practice committee. So that's 4 committee meetings coming up. That's my update. Any questions? Please remember to respond to doodles when you receive them. It's very helpful.
Thank you very much. So on item number 13, the update that I have, and I might reserve to bring this back because I'm still receiving callbacks from some of the people that we're looking at as it relates to different committee appointments. And also there may be based on what I'd like to do is based on a discussion that some of the results that will happen in item number 14, I would like to return and come back and talk to you about a committee that may result out of that, but it will make a lot more sense after we discuss item 14. So at this point, I don't have any further update until we address 14, unless any of the other board members know on anything they're working on. Tomorrow, we're going to address 14. I'm moving it on the agenda, and when we address 14, I'm going to bring 13. Excuse me. Thanks. Okay. So, first off, we're not taking 14 today. We're going to, I just want to make sure all board members have a packet of agenda items. Yeah, if you could make sure that you read this between today and tomorrow, it makes more sense on your time to give you time to read this and to go forth. And so we'll come back to that item.
Okay,
somebody else's. 'Cause I would-
Was there one that was in, she's,
Rich already put this in mine.
Yeah.
okay. Okay, yeah.
Is there more information about item 14 other than what was already in the packet that you want to give us time to read? Or?
That was only put in today.
It was put in while you were at lunch.
It was emailed yesterday morning
Oh,
and then added today.
you put it in our packet?
Yeah.
Very much. You took our packet apart. Oh, thank you.
Mm-hmm.
19.
So this is what your packet looked like until lunchtime today. All right. So now we are going to take some items out of order to make up for some of the time if everyone is so willing. We're going to move to agenda item. By the way, does our public have any comment on our committees? Want to serve on every committee? Where are you at? Tell us. Okay. Do we need to take a role where we bring in, I need legal to, we've now had board member Pavlovich join us. Do we just acknowledge on the record that she's here and that will, because we'd already established a quorum, for future votes, I want your name on the record. And welcome back, and we're sorry. Okay. The next item, agenda item 19, is update on the occupational therapy license compact and possible board action. You want to go ahead and?
So this table shows the states that introduced legislation to establish a compact in their state. And on page 2, it mentions the 6 states that have some legislation and excuse me, authorizing compacts. So 6 states in just this year alone.
What your overall takeaway is on that is, for those of, I'm sure those of you who are practitioners, you've seen all the articles that keep coming out. Because it brings. 2023, it's bringing us closer to, it's like the high 20, I almost want to say 29 is where they're at.
And then there's like 12 pending, and then plus
Right.
6 just did it. So it's gaining traction.
It's gaining
More
traction,
traction, more.
and again, I just want to, for those, we had a comment earlier, and I recognize, at our last meeting, one of the comments that came up is bringing this back when we know that the state of, that our DCA, the state of California, doesn't have any compacts. I also want to just remind everybody that we had a public member who really told us that it was within our authority and scope. And so I just want to remind the board that we can continue to dialogue, even if no other board goes with us. It doesn't mean it'll happen. It just doesn't stop us from putting the foundational work together to see if it could happen. That is within our authority, and we need to just remember that. Okay. So the next item, there's nothing more on this. Did you have any comments? I know you served on the compact, or the initial group. I did.
I don't. I look forward. I mean, it'd be very interesting if there was momentum to start an initiative to get a bill started on this at some point in California.
Got it. So what's before us is we are going to take a short break. It's 3:41. We are going to take a 10-minute break. Does that satisfy? Work for everyone? We're taking a 10-minute break, and then we're going to come back. We're going to address item 20 and 21, since we're moving 14 over tomorrow. And then I think we're in a really good place on timing. The board, I just want to make sure you all are aware, we do have a case for closed session, and if you have not had the time to review it, please do so. And with that said, I just took 30 seconds of that 10 minutes, so we're at 3:42, so now we're at 3:52, and we're going to take a break. Thanks, everyone.
I'm glad,
3:52.
I'm glad you went.
3:52, all board members are here and present. We still have public with us, and so we are going to continue. We are tabling, so in terms of today's schedule, we are coming back to 14 tomorrow, possibly 13, based on the discussion of 14. And moving forward, we have taken item 19 from tomorrow's agenda and moved it over. We're going to continue on with item 20. For item 20, we do have a public comment. The public comment is such, if everybody has a copy of the public comment. My name is redacted, OT, and I respectfully oppose the fee increases proposed to take effect January 2024. Multiple fee increases are excessive, including the retiree fee increase from 25 to 100. This is a 400% increase without any rationale to explain the reasoning behind how it was decided 100 would be the new fee. The proposed biennial OT license fee is 59% higher than the current fee of $220. In reviewing current regulations, there does not appear to be a fee to submit an application for advanced practice. New proposed regulation changes would require a $200 application fee to obtain advanced practice certification. This could potentially deter clinicians to pursue advanced practice certification. A more gradual increase in fees would have been more understandable. I've reviewed the minutes from prior CBOT board meetings, and I do not see a rationale to explain the reasoning for the amount of fee increases other than a comparison to license fees of other disciplines. According to CBOT minutes, CBOT paid to have a fee study by a consultant. If that is the case, the results of that fee study should be made public on CBOT's webpage. I don't think that that increasing fees during a time when inflation is substantially higher is sensitive to CBOT members. I appreciate the thoughtfulness of prior discussions and efforts for fiscal responsibility, including requests the CBOT board members revise the fee increases to be no more than 25% increase over current fees. Sincerely. Okay, thank you to our public member for that input. We're going to give an update. You want to provide that update,
Yes.
Heather?
Excuse me. I'll go into this in more detail tomorrow under my report, but you may recall, excuse me, when the board discussed this in August of last year, that the board was projected to be running out of money in the current fiscal year, necessitating a fee increase effective January 1, thank you very much, January 1 of 2024. That is not the case now. The fund is in a better condition. The good side is the fund is in better condition. The downside is that our expenditures were lower due to staff vacancies. Be that as it may.
Can we pause for just a minute to
Yep.
help you to, just so everybody understands in the public, the reason it's better than we expected, because it wasn't that our projections were based on what was happening then, and had we continued on the path with disciplinary in certain cases and continued on that path, we would have been there. But we're in a better position because the results were better than expected.
And so the good news is the fund condition is better. And so what we're going to do is take this time that we have now, and we're going to develop a communication plan, not to explain upfront, because, for example, the public comment talks about the board paid for a fee increase. Well, I'm sorry, for a fee study. We didn't. The board authorized that, which is a little bit different. What's also clear to me when somebody talks about the fees and wants it to be percentage based, this tells me it's not clear how deliberative the process was in order to establish new fees and increase a variety of fees so that the impact was not so great, specifically to the renewal fee, which is the primary, revenue source. So that's what we're going to do. We're going to use this fall, the opportunity to communicate more with the profession, explain more about the process, and we'll be seeking a bill for the fee increase in January of '24 with a 1/1/25 effective date, because the board can afford to do so now. That's my update.
Thank you.
Any questions?
So, anyways, that's why, when I read the latest version of that bill that we were gonna get folded into for a fee increase, that's why OT was not there, because it's gonna be a separate bill now?
Yes.
Okay.
Unless there are, again, other boards that all need fee increases, because that's now, it's a recurring sunset question, and that's the thing, from the policy perspective, they're not necessarily wanting you to be preemptive and take care of it in advance. They're wanting to kind of be responsive when you're down to the wire, and we're no longer down to that wire, which gave us a little bit more flexibility to be in a bill next year.
And to do more outreach.
And to do more
And be, yep. Any further discussion? Any comments from our public? Okay, moving on then. Moving on to discussion on legal analysis of proposed amendments to Assembly Bill AB 1028, reporting of crimes, mandated reporters, and consideration of taking a position on the bill. Helen, would you like to walk the board through this?
Okay, thank you. At the May 29, 2023 board meeting, it was requested that legal perform an analysis of this bill. I want to make it clear that an analysis of this bill is only as good as the draft that was present at the time it was analyzed. So this was effective at least on August 21st, 2023, and the version in place at that time was dated June 28th, 2023. So to my knowledge, a new draft has not come out. And then, of course, this analysis can be rendered moot upon any kind of changes or amendments. So with that, I will also advise that some of the legal advice is merely based on words, and so it's hard to see the picture of not being a health practitioner of how some of these effects are come about. So I will do my best to kind of answer any questions as to how that might affect the field. But I'm limited to what the words say and the intent of the legislature as put forth on the Legislative Digest, which is at the beginning of the bill. When researching law, we not only go to the statute, but also to case law, to any regulations, but also the legislative intent, which is included not only at the Council Digest, but as some of the supporting documents. But that's usually done with facts at the time to kind of weigh this out. So there are limits to this analysis, but with that in mind, I'll go ahead and let you know what I found. At that meeting, it was asked, do we have any background on why the legislature is pursuing this bill? Section 1 explains that the intent of the legislature is to provide access to health care and medical treatment apart from criminal legal involvement. The legislature found that requiring health practitioners to file reports with law enforcement can create a chilling effect on victims of domestic and sexual violence from seeking medical care, decreasing patient autonomy and trust, and resulting in health practitioners being reluctant to address domestic and sexual violence. The legislative materials did quote and reference a study I went to multiple places where the study was linked, and each time it came up with 404 warning, this document not found. So I was unable to provide any information to that effect. But if you click on the website, if it's not already in your materials, and you go to analysis, the analysis do include those quotes, but I felt that that generally summarized what was going on. The bill is drafted a little differently, and your copies are not in color, so it's going to be a little different to see. But if you look at Section 2, it says Section 11160 of the Penal Code is amended. And then if you look at Section 3, it says Section 11160 is added. What is going on is there's a current and existing 11160. This bill will amend the very last provision to say that on January 1, 2025, this statute in its entirety will cease to exist. And at that same time, the brand-new 11160 will then come into effect. And that is done on the 4 different statutes, something of that nature. So that is why if we had this in color, it would show a whole bunch of blue, even though it was showing a statute that currently exists. In 11160, these are the injuries that a health practitioner is required to report to law enforcement. 11160 does specify that law enforcement shall be informed and provides a timeline. This is not the end-all be-all. For example, for child abuse and elder abuse, there are other provisions of the Penal Code and the Welfare and Institutions Code that sets forth who shall be noticed, within what time, writing, phone numbers. I think it was elder abuse had an adopted method of uniform reporting. So it gets into great detail. This is strictly for all health practitioners. When having this type of injury, they need to report to law enforcement. Current law provides that there are generally, there's 2 of them in one section, but there are 3 types listed as number 1 and number 2 on your page 2 of 12 in the document under Section 2. A health practitioner shall report when there is a wound from a physical injury that is self-inflicted, or where there is an injury by means of a firearm. So that's all in the paragraph there, not subparagraph, but paragraph 1. So if it's self-harm or if it's by means of firearm, a health practitioner shall report. Number 2 says that if someone is suffering from a wound or physical injury from the result of an assaultive or abusive conduct, then they shall report. Subdivision D, which is located on page 3 of 12, starting in approximately the middle of the page, begins to list all the items that are within that term, assaultive or abusive conduct. In your packet, just before the actual legislative materials, you'll find a chart that I created. It takes subdivision D and lists out all of the requirements that for all injuries that would need to be reported. So there's a list of, I'll guess at about 15, 20. Within this list is elder abuse and child abuse. So in the new adoption, the legislature is proposing that term assaultive and abusive conduct and this entire list of potential injury-causing incidences is completely deleted. At that time, the legislature is adopting that we will now, or health practitioners will now need to report self-harm injuries, injuries from a firearm, child abuse, and elder-dependent abuse. And then that's it for mandated reporting. So if you look at the chart under the 1028 requirements, it goes through and kind of lists where you see report. Certain things such as, where's the first one? Oral copulation, That includes rape as well as to children. And so the rape would no longer be considered under this type of reporting, but the activity to a child would be as a method of child abuse. So some of these get split, and some of them, the bill then becomes silent. Now, this analysis is for this bill only. I cannot speak to other laws that may exist or what the legislature intends beyond what they list in the legislative digest. They are silent in the legislative digest as to what they intended or what they expected or what was the specific direction to health practitioners regarding the injury sources that are listed here that are now no longer part of this provision. The 11160 also defines a warm handoff for those things that are sexual or domestic violence in nature. And again, in the report, you'll see where it says warm handoff. A warm handoff or a referral. And a warm handoff is a direct contact with a survivor advocate, either in person or on phone. If a phone call is not possible, an email will suffice. And the victim can also refuse that service. And also a referral in which you are, the health practitioner is informing the patient as to where to get this information, the contact information for an advocacy group, and what this means and what to expect when they contact that advocacy group. And so that will become the new responsibility for health practitioners when encountering these types of injuries on a patient. Are there any questions about 11160?
So the word warm handoff is actually in here to find the whole bit. Who came up with that word? Our legislators or?
I don't know the source, but yes, the legislature has adopted that phrase, but I don't know if they took it from somebody. But that is defined on page 6 of your 12 at subdivision N. N is in Nancy.
Because it seems like there's report, it seems like that there is, to me, warm handoff is inform, report, inform, refer, get it? So, but I'll just take it up with my legislators, I don't care.
Well, it's a little more than inform because you're actually putting them with another individual.
Inform.
Yeah.
The word, but the word.
Only an email if a warm body is not available.
Yeah. So, okay, so really what this is about is, even though the legislation is about removing and replacing with this, removing what were mandated reporters, it's not that they're removing the entire list. They've divided out those 4 items we must still report, those items we must do something different in the form of a warm handoff, and those items that we make a referral. And then they've given definition of that, those items for each. Which
Yes.
is what you just went over. Okay.
Yes, so subdivision D lists approximately 15 to 20 methods of injury that currently a health practitioner shall report. And now that list is divided into shall report, and of that list, child and elder abuse is now required, but the other ones are not. And then a warm handoff is required for sexual or domestic violence. But there are items in that list which are not addressed nor commented on by the legislature as to what happens if, say, a third party as opposed to a spouse creates the harm, or anything of that nature. But if it's sexual in nature, it will mandate a report if there's a child involved, and it will mandate a warm handoff if an adult is involved.
Also, my understanding is the difference is who we report it to, right? It's the law enforcement versus non-law enforcement. So they're changing it that those four issues or four items go directly to law enforcement versus the other stuff they're removing now is not law enforcement, so that if you report to law enforcement, you're in violation of this.
So, correct, except you may report if the patient asks you to. So I wouldn't say that it's prohibited, but yeah, they would have to ask you to. You can offer, as a health practitioner, would you like me to call the police? And that is part of the provisions saying that you can offer a rape kit, you can offer all of these options, but you're not mandated to report without their consent. And then it's always to law enforcement under this provision. And so now those that remain, the child abuse, self-harm, et cetera, those now shall still remain, because it's not changing who it reports to, still police, law enforcement, and the other ones are to an advocacy group.
Any other comments? Ellen, do you want to follow up? So the action before the board is to either take a position, let me read the exact wording as written. It is consideration of taking a position on the bill.
Would you like me to finish analyzing the bill, or?
Please do.
Okay, I'm so sorry. But yeah, ultimately what we're looking for is either a watch, a support, or what is it? Not rejection, what is it?
Oppose unless amended.
Oppose unless amended, or support unless amended, or support with amendments. But basically, what are we going to tell the legislature, if anything, about BOT's feelings about this particular statute proposal? The amendments to Penal Code Section 11161 changes physician or surgeon to health practitioner or member of the care team as the party that shall report. The amendments to 11163.2, confidentiality and permissive release of healthcare practitioner. This one required additional research, and so again, I do want to assert that the legal analysis is limited only to what the words are and what the legislature puts in its digest. And I cannot speak to other laws or requirements or whatnot, but I did go to the Constitution for you. So in here, it says, reports required shall be kept confidential by the facility. And in no case shall the person suspected or accused of inflicting the wound or their attorney is allowed access to the injured person's whereabouts. The new provision omits the statement abusive or assaultive conduct. And so now it reads that the reports, because assaultive and abusive conduct are no longer subject to a report, the reports required shall be kept confidential, but in no case shall the person suspected of inflicting the wound or their attorney shall have access. But now this, with that omission or that deletion, this will now only apply to those who are self-harmed, harmed with a firearm, child abuse, or elder abuse. So this phrase, this whole section applies specifically to health practitioners. And this now reads on its face that it appears that the whereabouts of an injured party would not be protected against disclosure to the person who caused the injury or their attorney. There may be other protections. This may not be the end-all be-all. It may be that this is about the report, but I'm unable to opine if this creates unintended consequences, if this is simply conforming language, or if this now creates some uncertainty. And without comment from the legislature, I don't have much. I did go to the Constitution. Our California Constitution, Article 1, Section 28, provides for victims' rights. It says that a victim shall be entitled to prevent the disclosure of confidential information, which can be used to locate their position or harass them, etc., from in the course of medical or counseling treatment. Without that provision in statute, it's possible that the legislature intended but did not comment, so this is hypothetical, that this constitutional statement was sufficient. However, I will note that it says it puts the victim shall have the right to prevent disclosure, but as to what that would mean in actual practice is beyond my knowledge. How this can be interpreted with the medical or counseling treatment of, in the particular case of our occupational therapist, handing it to a survivor advocate, I don't know at what point that goes beyond our scope, and so therefore counseling is not going to be defined as something within the capabilities of an OT. It may be incredibly broad. I have no information for you. I just know that at this point, this particular statute omits the protection or the requirement by a health practitioner to maintain the report confidentiality, which there's not going to be a report, and to not disclose the injured person's whereabouts. It now appears silent. And so I'm unable to fully analyze this as to how this would happen in the real world.
I have a question for you on that. The statement unable to report unless it's the 4 mandated items, or the patient says, yes, I want you to file a report that I've been raped.
I'm sorry, what?
Are you
When-
summarizing?
I'm asking the question, when you just made the same statement to us and said it would not, you're identifying what would not be included with this new legislation. The flip side of that is what this legislation is the 4 items that would be mandated reported, any of those other items where we could weigh in, and lastly, if the patient says, I want you to report.
Correct.
So we do have the ability. It's not like it's an either or. We do.
So let me put this, I tried to put this into practice in my head. So for example, on the most blatant of the applications of this, someone comes in with a domestic violence and there's no report made. And so this statute theoretically does not apply when it comes to the report. But if the spouse who abused the victim were to ask, previously, as listed as an assaultive or abusive conduct, the health practitioner shall not disclose. Now, instead of this statute, we rely upon the Constitution, which is directed towards medical and counseling treatment, but is not as clear as this statute once was. So now a domestic violence abuser comes in, asks for the location of their spouse, and I'm not saying we would have to disclose the location of the injured party, but the words that are now missing here no longer apply to that situation. So there may be other terms and protections and whatnot. I'm unclear as to why the sexual assault and elder abuse, sexual assault and domestic violence is not referenced in here, such as also do not, this also applies to locations of those we provide a warm handoff to, for example. So it's suddenly, I'm unable to measure without actual facts as to what the legislature intended, what they believed, what they felt was accomplished or not accomplished by doing this. I just know that where we before had sexual assault and domestic violence was included in what we shall not provide and this location protection, I no longer have. And then, as in your chart, there are sources of injury that are not addressed at all, including manslaughter and torture, and of course, assault by a third party that's neither sexual in nature or not a domestic partner. And now these aren't reported or warm handoffed. So those also are now omitted from this particular provision. And I do not know what the legislature, where they were going with this.
They're omitted from the provision of a healthcare, let's not forget the words mandated reporter.
Correct.
Because in practice, if you were to talk to some licensees, they'd tell you that they've had to over-report. So I think that's might be the flip side of what went before the legislature. Looks like our public wants to comment.
Well, if I could just
Yeah.
clarify that, like I said, this would change the mandated reporting requirements. So if neighbor A was beating up and victimizing neighbor B, and B came in and received our assistance and said they were being victimized by neighbor A, today, a health practitioner would be mandated to report to law enforcement. If this law were adopted as is, there would be no requirement to report that.
Got it, thank you. Thank you for your deep dive analysis. Is the board okay if we go the public? Looks like,
Yeah, we can go to public at any time.
I'm going to build on what you said too. It also is the child who lives in a home with a mother's boyfriend, right? Because now the boyfriend is not covered here.
I probably go fact by fact,
Right.
but the phrase domestic violence is pretty broad, and it does include people cohabitating. Roommates get a little weird, but generally a boyfriend and then a child, usually that would be interpreted as domestic violence. But you're right, this is no longer clear because just simple assault, if the boyfriend didn't live with them and maybe they happened to have broken up that day, I mean, now it gets weird. But upon a child, then that would mandate reporting regardless. But if that child or that daughter or the son is 18, would not.
Yeah, I wish I didn't have to do as many mandated reporting things as I have done in my 33 years, but I've done a lot, and they've been heartbreaking every time. And I'm the one who teaches our students about this. And what I always say is your takeaway here is that you are not to investigate. It's not your job to investigate, right? It is your job to tell people who know how to investigate something's happening here, and they will figure it out. And I feel like this muddies this, right? Because now, if I just heard assault before, I could go forward. But now I got to determine, is it assault with intent to commit mayhem, rape, sodomy, or oral copulation? Those are questions that are going to erode my therapeutic relationship, right? Like, those are roads I shouldn't go down unless I have a team of psychologists behind me. And sometimes I have, but sometimes I haven't, right? And that just seems bad for everyone. So I think this makes it much more difficult for occupational therapists. I think if their intent was not to mess up the therapeutic relationship, I think they've done the opposite, right? Because they're requiring us to discern very specific things in ways we didn't have to before. And then the warm handoff really concerns me because, what was it? Survivor advocate. Like, I feel like you could work with some social service agencies that are associated with religious groups, right? And they would say, oh, well, we'll be the survivor advocate, and our belief is that somebody stays with their spouse until death, right? Like, that survivor advocate is too nebulous. Like, I didn't have a problem turning it over to CPS or the sheriff's office or whoever. They were clear, and they had procedures, and they had policies, and they had professionals. And this doesn't do that. So I find it alarming.
And thank you. She did make a point. I could not find a definition for what survivor advocate included. I do not know if it's limited to only groups that serve sexual or domestic violence services, or if they could also be more broad, I suppose, religious in nature or some other focus, or what the legislature intended by the phrase survivor advocate. I do not have a definition of that. If it exists elsewhere, could not find it, and of course, it would be outside of this bill. This may be a phrase that's very common, but yeah, I do not have a definition for that.
So I'd like to pull this back, if I can, just a time check. We're at 4:25. What's really before us, this is a very good deep analysis of what the law is. What's before us as occupational therapists is, do we support? Do we support if amended? Do we oppose? Or do we unless amended, or do we reject? And so when we look at those four items, if we oppose unless amended, then what's before us is to come up with some very specific bullet points. If we want to reject,
Or just opposed?
oppose, yeah. Do we have to give reason if we just oppose?
Yes.
Okay, so either way, we're going to have to give reason, but I think we need to move the conversation to this board. Do we have enough of a deep dive analysis, enough public comment to get to an action on this? Anyone have any thoughts?
Would be after me, I would just oppose it because we're here to protect the consumer in the state of California, and this bill does pretty much the opposite, gives an open window for a criminal or, the person who did something really bad to be like, oh, well, I wasn't within that category, so they can get away with it.
So oppose, what was your first statement again, Beata?
I would oppose.
Because of consumer safety, so there's the bullet point. Oppose, one reason is consumer safety. From our public member, I'm doing this to help the board decide what we want that result to be. But from our public member, we also heard that, you talked about a couple of.
Legally, what she would say that kind of condense it, and please correct me if I'm wrong, is that it puts an onerous on the licensee to investigate and to take a deeper look in order to determine if it qualifies as reporting or warm handoff or nothing at all. And it also, there was something else. But anyway, but basically the term investigate I thought was really strong, and it muddies the waters for clarity as to when they investigate and when they simply report, to hand it to people who are more properly able to investigate.
And I think my other point was that the survivor advocate wasn't well defined and could be misused.
You also did use the word, I thought, scope, when you talked about there would be certain things that for you to go down that path would be out of scope without the experts behind supporting you. Christine, were you going to?
Say what she just said. But you also said something, though, about not negatively impacting the healthcare practitioner and the patient's relationship, right? I mean,
That therapeutic use of self, that was it.
Yeah.
And I think, yeah, that was a critical, it was very compelling, because that's at the heart of the occupational therapist distinct value.
And we work with all the high-risk populations, right? We work with elders, we work with children with disabilities who have a 30% higher rate of abuse than the general population. We're right at the front line.
Can we get a pulse from the board where you would go, and then we'll do a read back? Which of those, Helen, do you want to identify the four position, the support that?
I'm a little rusty, but there is support, oppose, unless amended, and then support unless amended, if amended. I will say this is a proper position to take. It's listed as an option. As legal counsel, I am uncomfortable with the position of support if amended, in case the amendments become something we don't want. But it does have its own little political twists and turns. But those are your four options: support, oppose, or watch.
Or not
Support,
position.
oppose, unless amended, support unless, if amended, and watch.
So where are we?
I'm at watch. And I'll tell you why, because this is bringing, this is a different perspective. Because I'm not talking about occupational therapists, I'm talking about domestic violence survivors and children who have been abused and stuff like that. Because, in our society right now, we victim blame a lot, and a lot of people who are afraid to report because of the repercussions of reporting, and they feel that it's more of a traumatic experience, and they feel like it's useless if they report it. So the whole reporting to law enforcement makes it even harder for someone to go back to a healthcare provider once they are told that we have to report that issue. And so that's why I said watch, because from my personal background, I would not, I would not oppose this, because I think there is some good to this. And if you delve deeper into the thing and why this was brought about into the legislation, but I'm at watch right now.
Okay, great.
And just to be
And
clear, if there are,
we'll move forward to,
oh, I was going to say, if the board wants to make items clearer, support the bill, but, these are things that would move the legislature closer if there are confusions, this is the time to, those would be the comments that would be added to the legislature. So I didn't know, besides just watching, if we knew we wanted something, that would be where we would go.
Right, because if it passes and then it's gonna be, oh, whoopsie, it's too late, we didn't even comment on it, one way or another.
so I only hear one person saying watch, guys, so I've heard oppose, I've heard watch. Sharon, I know you're thinking about Board Member Pavlovich. Christina, do you have a definitive thought, or are you still thinking? I'm probably leaning toward oppose. I am too. You're opposed. Where are you at?
Well, I'm just kind of looking at the support and opposition in the last Senate analysis, which is, so it's supported by a number of organizations having to do with, including, there's a whole bunch of, there aren't any licensing boards on here. There aren't any other licensing boards either opposing or supporting it. The opposition is there are a lot of law enforcement is in opposition, almost all of them, and almost all of support are Family Violence Law Center, Los Angeles LGBT Center, Safe Place, ACLU, California Action, California Academy of Family Physicians, California Consortium for Urban Indian Health, California Faculty Association, California Nurse Midwives Association. So a lot of, they're legit, and then the Police Officers Association of San Diego. So they're legit people on both sides of this issue. The assertion is, when we talked about this last time, I was like, I don't have enough information about whether it's true or not true that people are not getting care because of this mandatory reporting. They have some stuff in here, but I still don't feel confident about that. So I think I'm kind of with Lina on watching.
Okay.
And it also died last year, and it's in the appropriations. It's going into appropriations on the 28th. The hearing was postponed. It was supposed to be in appropriations last meeting, and it was postponed. And I think maybe 2 meetings have been postponed. So there's a lot of. We have an opportunity if there is a hearing on the 28th.
Thank you. So you're at watch. Hector, Board Member Cabrera, where would you be?
Major senior moment here. We're talking a mandated reporting.
Right. And did you see the chart in the book that was provided by legal? It tells you what's kept in and what's taken out.
And from what I'm understanding, on the 28th, there's going to be a review.
Well, it's scheduled on appropriations on the 28th.
Of August?
Yeah.
Are we going to take a position now, or can we?
What do you think? What do you think we should do?
After the 20th?
No, today.
Today?
Well, if the 28th is your compelling evidence, then your vote would likely line up under watch. Your recommendation, I mean, to the
Then
board
I
would.
would go with watch.
Okay. Okay, so it looks like, certainly, just so you know, it looks like, based on the polls, thanks everybody for going through that, it looks like we have a majority that would watch this. And so, do you need a motion that we're gonna watch? And secondly, we're gonna watch it. Staff's recorded, this will be in our minutes, all the reasons why we wanna watch it, including the hearing on the 28th. I would add that as a reason, because that was.
There's several issues that we're having with this. Why could we not express them? Like, they need to know this before they keep on passing this bill.
I
I
agree.
mean,
I do want to say that September 1st is the last day for fiscal committees to meet and report on bills. So with them scheduling the hearing, like, right at the end, there's not going to be another opportunity, how all the
yeah, we
committees.
have, yeah, just
But-
watch, I mean,
but it
we
could
strongly believe there's many issues within this bill, right? You agree with it? That there's many things that are not okay, and the consumer wouldn't be protected, right?
I see the positives to why this is being proposed. So,
Like what?
For the consumers of occupational
no,
therapy,
that's what I'm saying.
so that's the board you're on.
The consumers of occupational therapy, if it's the same thing, if they are reporting this, and like, as our public member said, that they're gonna have to do more investigation as a therapist doing this, as a licensee, it's not gonna make it easier, and it's gonna make the individual more likely not to want to come back to get healthcare services. So I see why they are trying to remove that component, but it is that fine line where is that abuse that they are reporting going to fall in one of those categories, saying yes, right, that they're gonna keep the mandated reporting. But the reason for the warm handoff is so that the person gets services that will be more helpful for them than being reported to law enforcement, where then they go to the criminal system and have to deal with courts and reports and all that stuff that makes it really difficult for them.
But what if they keep being abused though, and there's nobody can do anything about it? Like, nobody's gonna do anything against the abuser.
But-
The point is,
That's.
a person who's being abused will not get the help they need until they are ready to admit that they are abused. So with the fact that there is in there, that it's written that we can report it to law enforcement if the individual says support to law enforcement, then that also aids the person's decision to get the help they need.
And these are all really good comments that they're going to vet through in the legislature. Just, again, pulling us back. If we watch, we're not submitting any if we take a different position, we can get our comments in. The point, I believe, that our vice president brought up was, why would we not take a position? Why?
We can, but I would not support an oppose on this court. I do not feel that this is protecting the peace.
So if not watch, just thanks for going this, if not watch, and again, I know it's like very compartmentalized the way we're looking at it. All of the things you're saying are validated. When I come back, I'm not weighing in on whether I agree or disagree, but in looking at the action before us, if you can't support, or if you'd like watch, but you understand that means the board won't be heard,
If I had to choose to oppose support, I would
support if amended. Because I think you have to meet us halfway. We've got 3 oppose. Do you know what, we've got 3 oppose, and so support, you, then I changed my vote to watch.
What kind of amendments do we want? Because I think if we say support if amended, we need to put out what kind of amendments we
Well, I think we have some of those bullet points. That's why I wanted to take the pulse. I do think we have some of those bullet points. If we got to consensus on something along that line, then, then we can go next to what those bullet points are.
I have another wrinkle.
Yeah.
The hearing on the 28th, actually, the post the agenda tomorrow. So
Yeah.
maybe we'll know tomorrow if it's actually going to be heard on the appropriations the 28th or not.
Or yeah, it could be held in committee. It might not make it, they might not hold the hearing, they could hold the hearing and it doesn't make it out of committee.
Right.
That could happen. That's kind of what I was saying about that.
We
section.
could bring this back tomorrow.
And just
We
see if
we
it's
could
posted,
very
if
much
it's on the
bring,
agenda.
yeah.
If it's not on the agenda,
It's actually a good point.
And then I could call the author's office.
Because it would be a wasted effort.
I could do that, but not after 5. There.
So prior to 5 o'clock, our executive officer can call the author's office.
Okay.
And we will also have so where we need to, so are we okay?
Tabling this until tomorrow?
Tomorrow.
Yes.
Great. Okay, so then what's before us next? Did you have any further comments?
The thing I would add is that when you say the consumers of occupational therapy, I think I kind of had a very different consumer in my head than you do, right? And so the consumer I work with is typically
You can go.
not legally determined to make their own decisions, right? That maybe they're homeless and mentally ill, or maybe they're children, or maybe they have disabilities. And so I guess that is what I'm holding in my head when I think of who we're trying to protect here. So that would be the only thing I would add.
And I understand that. I mean, but I think we also need to believe that if a child is being abused, that we have to listen to them and they will say something, you know.
The ones that
you
are
know.
able to do, but many the ones we work with can't.
Excuse me,
This is what it's.
but child abuse is included, so it's not like, that's not a warm handoff situation. So that actually doesn't even apply. I mean, it's an important, I mean, I appreciate the discussion, but if you're talking about child abuse or elder abuse, they're still mandated under this law. So that's not a good argument for making a change on this bill. I would have to argue but your rape situation, your domestic abuse situation, those are, so.
Well, Richard, I think in her case it might not be a good argument, but I think it's a good argument in a lot of other OTs cases. Yeah. So I appreciate you bringing that up.
Okay, any further comments? We will bring this item, thanks for the robust discussion, a lot of great input. And thank you so much. We will bring this back tomorrow. What's gonna happen now, just so our public is aware, is we're going to go into closed session. And we're gonna go into closed session at 4:44. When we're done in closed session, we're gonna come out of closed session for all of a minute to close the meeting. That part won't be on camera. What will be in the minutes will be the adjournment, because just logistically, that requires me to keep the cameraman here to open up for 1 minute and close, and that's not fair. So it's all reserved for us that we get to stay as the board, but we're going. Yeah, it's gonna take a while. You're
Okay.
gonna get a natural break, so I'm not adding a break. Okay, 4:45, the day 1 of the Board of Occupational Therapy, Thursday, August 24th, 2023, at Samuel Merritt University is going into closed session.